Welcome, everybody. It's a pleasure to see you all here today. This is a great moment for us, a collaboration, our first collaboration between the Institute for Feminist Legal Studies and Sonia Lawrence and the Osgoode Colloquium in Law, Religion, and Social Thought. And we're delighted, Sonia and I both, at a professional level and very much at a personal level as well, to be able to welcome Professor Ngaire Naffine to Osgoode for this talk. Professor Naffine is our first Genet lecturer this year as well, and she's going to be speaking next Monday. So if you like what you hear, and you will, come back next Monday, and the Genet lecture promises to be a wonderful talk, and one that's connected in many ways to some of the themes that Professor Naffine will be discussing today. Professor Naffine is a professor at the University of Adelaide, and she's a creative, powerful voice in criminal law, in jurisprudence and legal philosophy, in feminist legal theory, and she's made some tremendous contributions in recent years to debates around the intersection of a number of social forces, religion amongst them, and law. She edited Ashgate's wonderful collection, Gender and Justice. She has a broad range of publications. And if you're looking for a book that will enrich and amplify your thoughts around the nature of law, Professor Naffine also published in 2009 a brilliant book through Hart Publishing called Law's Meaning of, here's a title, okay? Law's Meaning of Life, Philosophy, Religion, Darwin, and the Legal Person. So Professor Naffine is going to speak for about 50 minutes or so, and then we'll have about a half hour for questions and comments. And so please join with me in welcoming Ngaire Naffine to Osgoode Hall.
Thank you. Hello. Thank you very much for having me. I have a bit of a cold. I'll do my best. I'd like to thank the Genet Global Faculty Fund, Sonia Lawrence, and the Institute for Feminist Legal Studies, and of course Ben, and his colloquium on law, religion, and social thought. I'm going to start with a poem, which is highly relevant to what I have to say. It's by the poet laureate that was, I believe, Philip Larkin. Sexual intercourse began in 1963, which was rather late for me, between the end of the Chatterley Band and the Beatles' first LP. Up to then, there'd only been a sort of bargaining, a wrangle for the ring, a shame that started at 16 and spread to everything. Then all at once the quarrels sank, everyone felt the same, and every life became a brilliant breaking of the bank, a quite unlosable game. So life was never better than in 1963, though just too late for me, between the end of the Chatterley Band and the Beatles' first LP, and I hope those two references are not lost on half of this audience. My paper is perhaps heroic in ambition. It is to characterize the legal person, especially the person thrown up by criminal law, before and after the sexual revolution, and to reflect on the effects of this character of the rise of the modern married woman. How, if at all, have changes to the lives of married women, their modernization, refashioned the character of the legal person? I'm drawing a long bow. Over the course of the 20th century, in the common law world, married women's lives changed a great deal, especially in relation to their husbands. And my suggestion is that these changes have necessarily exerted their effects on the character of the legal person. If we take the right to bodily integrity, the right to demand physical separation from all others and put them at arm's length, as perhaps the most fundamental person-defining right, then we must say that at the beginning of the 20th century, this personal rights-asserting being was thought of as a man, be he single or married. By the end of the 20th century, it was perfectly thinkable that this character could also be a married woman. In what follows, I will suggest that at century's start, the married woman was legally, socially, and religiously understood in terms of her subordinate relations with a man, indeed by her merger with a man, her husband, within a notionally private arrangement to the family. Her place, her life, her character was in many ways as prescribed and ordained by the family and the church, with the connivance of civil and criminal law. And her personal and sexual sovereignty in relation to her husband were not part of the deal of marriage, not part of the deal of marriage, as religiously and as legally defined. She signed up for merger, not for a separate life as a liberal individual. There was little controversy about this from the law, from the church, or from women themselves. By century's end, by the end of the 20th century, and now I imagine for all of you studying law, the married woman was simply not understood in this manner. She was permitted to disengage and be a separate legal individual and had a full right to exclude, at least in a formal sense. These changes to married women's lives did not occur all in one moment, of course. There's been a slow shift of mentality, a slow shift of habits of thought. There wasn't a single critical legal decision, not the person's case as though that was relevant, not the suffrage. Many things happened, but there was gradually a shift when one way of looking at women was thinkable and then a completely different way was thinkable. A change of legal attitude to a more modern way of thinking about married women and thinking of us genuinely as legal persons. So to state my argument clearly, the idea that the married woman has a fundamental right, as against the rest of the world, including her husband, to full bodily integrity, a right supplied by criminal law, is new in historical terms. And in many ways, this is an historical paper taking about a century of thought. And this change I'm suggesting is very important because it shifts our thinking about the character of the legal person. True, as a practical matter, these rapes don't get to court. Most rapes don't get to court. I'd be surprised that it were different in Canada. I had a colleague who suggested that rape be made officially lawful because that would match the statistics. So in practical sense, there's not a rush of women into the courts. Nevertheless, I think there has been an important symbolic expressive change in thinking. A change to the zeitgeist, the legal, social, and religious zeitgeist. Does everyone know what a zeitgeist is? You're so educated here, it's wonderful. And it has a bearing on the character of the legal person. So there is emerging a more complex, less unified understanding of the rights and duty-bearing person of criminal law, in which married women now have a greater formal presence. However, there are countervailing norms, and I will be talking about them at the end of the paper. In the course of one paper, though I am given to the ambitious, I can't undertake a full social and legal history of the married woman over the passage of a century and then trace the influences of this history on the legal person. However, I'm going to try to sketch important changes and use some, I suppose, heuristic devices. I'm going to be very selective in order to trace this filiation of ideas. I'm going to make a bold move, having said that the change did not occur overnight, that there was a very slow change in thinking. I am nevertheless going to choose 1963 and the Philip Larkin poem as the dating of the sexual revolution. Highly artificial, I know. I'm also going to draw on an English study of married life by Schrater and Fisher. And they dated the sexual revolution at 1963 as well. I can tell you more about the Schrater study later, but a very distinguished empirical study in which the two historians went into the homes of an older generation of men and women and really asked them about their sex lives. These are people born in, say, the 1920s and the 1930s who never talked about it, but gradually became forthcoming. And much was revealed about what they thought their obligations were. What did they think they'd signed up for? This is important because we often just get a top-down view of law, what lawyers and what judges think, what law reforms think of it. This is a sort of a history from below, where you find out that the people whose lives are being lived and shaped by these laws, what they think they are allowed to do, what they should do. And I'm going to make another economising move. I'm going to draw very heavily on a very recent Australian landmark case on marital rape, PGA. It's the case of Mr. and Mrs. P, which used similarly bold brushstrokes to characterise attitudes to sexual autonomy and marriage before and after the sexual revolution. Quite remarkably, the alleged rape was in 1963. Mrs. P, came forward in Adelaide a couple of years ago and turned up in a magistrate's court, a lower court, and said that she was raped. She had complained before. She'd been to the police many years ago. There were institutional reasons for her feeling that she might get a hearing this time, and in fact that the case got underway. The prosecution decided to prosecute, absolutely remarkably. And it was appealed. It hasn't even got to trial yet. This is a case where the first question was this a crime at all in 1963? And that's where it is at the moment. The district court, which is about halfway down, pushed it up to the Supreme Court, our state court, and said, was this a crime known to law in 1963? And the court said, yes. And then it was appealed up to the High Court of Australia, which is our highest court. And remarkably, our High Court of Australia has answered in the same way. And we have yet for this case to go to trial. And getting the evidence is going to be tricky, obviously. But in this case, the lives of married women in Australia, and really in the rest of the common law world, were expounded and argued quite starkly. In fact, there was talk of life for married women before and after the sexual revolution, before and after 1963, the alleged rape time. And I'm going to employ the husband's immunity from the prosecution for rape as an important emblematic law. I'm saying that this law can do a lot of work for us. It's highly expressive. Michael Moore, the American criminal lawyer, said that the insanity defence was the royal road into criminal law and criminal responsibility. And I think similar things can be said about the marital immunity. I think it tells us a great deal about the relationships between men and women, society, social organisation, the institutions of law. I think it's highly informative. So, though sometimes I wonder why I'm reading so much about marital rape, I also think it's a very large topic. It's a very rich topic, a big seam of ideas, a rich seam of ideas. So, my paper considers the effects of the changes in married women's lives over the course of a century on the character of the legal person. And obviously, I'm going to have to say a bit more about who this legal person is. Is everybody familiar with this concept of a legal person? No. Do they know?
What
do you teach them?
I I'm not sure what
I
you're
mean.
all in. You might want to unpack it for
I
me
think I'm going to need
briefly.
to. Yes, indeed. I will unpack it. Right. That's what my husband said last night, and he's an historian. Okay. I will be talking about this concept of the legal person and what work it's doing. Before the sexual revolution, this paper is really going to be a before and after story. I need only to explain this character of the legal person fairly briefly, but perhaps longer now. As Jennifer Nedelsky describes this individual as, and here she is using it as both a political and a legal concept. She says, the prevailing liberal conception of the self, she calls it, is an autonomous self with rights, and in law, it takes a liberal form, and it protects equal, autonomous, rights-bearing selves from harm from each other. So there she's using the idea of a self or an individual or as a person as a political ideal. And Ratna Kapoor, who's I think been one of my predecessors here, has recently asserted, and here she uses the term liberal subject. So here I am conflating it with a liberal political ideal of an individual, you and I. The liberal subject lies at the heart of the human rights endeavour. This subject is free, unencumbered, self-sufficient and rational, a sovereign, autonomous subject. So a political ideal. The important idea is that without an enforceable legal right to exclude others from one's person, one is hardly a person. The 17th century political theorist John Locke supplies the classical formulation of this liberal individual. Every man has a property in his own person, nobody has any right but himself. And John Stuart Mill insisted that in the part which merely concerns himself, the individual has an absolute right. Over ourselves, our bodies and minds, we are sovereign. And this is actually the starting point of criminal law. The law of assault, the law of the offences against the person are keep out, don't touch. The basic crime of assault is a crime of don't touch without consent. So there within criminal law is an idea of a person, and it's also a set of rights and duties. My last book, is really about this flipping between a political idea of a person, a physical idea of a person, me standing here as a human being and a woman, a religious idea of a person, and sometimes a highly abstract idea of a person. I might just say a little bit more about this abstraction. Legal personality to lawyers is usually regarded as a piece of artifice. It's a basic legal unit. It's a set of rights and duties. Any of us at any moment come together as a legal person, a virtual person. You can add up all your rights and duties sitting there having your lunch, what can be done to you, what you can do to other people, the contractual relations you have with people, the tortious relations you have with people. As you combine them into a set of rights and duties, you are sort of zapped into being as a legal person. And we all go around as legal persons. I go around as a legal person half my life. It's a very tiring way to think about yourself. And I'm sure non-lawyers don't go around feeling like legal persons, but I do. And it makes me very adversarial in the street when I think of what people shouldn't be doing. But I was yelled at very loudly 2 weeks ago in the streets of Adelaide for telling people really that they were using offensive language, which was proceeded to be used on me. And then I went home and thought of all the offences against the person I'd just been a victim of. I was thinking about this at the time, which is rather foolish. So the starting assumption of criminal law is the basic crime of assault. And homicide and rape are likely to be treated as the interesting core offences, and they're really all about don't touch. Case of Collins and Wilcock, Lord Justice Gough said, fundamental principle, every person's body is inviolate. It has long been established that any touching of another person, however slight, may amount to a battery. And William Blackstone was cited as the provenance of the rule. And Blackstone said, you can't draw a line between the different degrees of violence. Therefore, law totally prohibits the first and lowest stage a very strong legal assertion from one of the great common lawyers, every man's person being sacred and no other having a right to meddle with it in the slightest manner. No right to meddle with it in the slightest manner. A fundamental right of a person defined as the individual who can keep the other off. Jennifer Nadolsky has characterised this person in her extensive and wonderful writings on the bounded individual. She says that's a very powerful conception that we have in criminal law. A person with a wall around us. Charles Reichs has used it for property law too. We stand here with a wall around us. And it's a fundamental right, and it's fundamental to liberal law. Now, I think it's right to say that women, and especially married women, were not considered part of this liberal project. This central idea, the liberal idea of the person as a strong rights-bearing person who can keep all others at a distance, and it's fundamental to their personhood that there is this boundary around us. If you can get close to me and I've got no right to stop you, I am weakened as a person, as a political person and as a liberal person. Criminal law positively removed the rights to bodily security and integrity of married women. It was absolutely implicated in relation to the crime of rape, though not of assault, which is a very strange and chilling distinction. You could not assault a wife, but you could rape a wife. And that really shows how rights and duties are highly artificial and can play out having different effects, even for the one act. It also partially excused the violent controlling husband through the defence of provocation. I hope I've got this right for Canada too, a partial defence to the crime of murder, reducing it to manslaughter if the assailant is sufficiently provoked. And the classic example of that has been the woman who does him wrong, sort of the jilted wife. And that's still been the classic formulation. And in many jurisdictions of Australia, the defence has been abolished for exactly this reason. It's not a good thing to tell people that a wife can partly get away with murder if he is outraged enough at a disloyal wife. Now, to the case of PGA, which I think helps to throw light on the political, social and legal view of the person prior to the sexual revolution. There was a very brave QC in this case called Mr. Bennett, and since I had just read Pride and Prejudice, I keep thinking of Mr. Bennett in this way. He presented a very bold argument and got far too relaxed in front of the High Court because he ultimately alienated them and lost. Mr. Bennett wanted to argue that rape was not a crime in 1963 and therefore his client had committed no offence known to law. And so he got stuck into Australian society. And really, Australian lawmakers and Australian judges, even though he was standing in front of the most powerful judges in Australia, telling them that they probably themselves were part of the Dark Ages. He said that 1963, which was the date of the offence, was prior to the sexual revolution. He said that Australian common law and society, and probably the rest of the world as well, and I think he was thinking of Canada, assumed a pre-Enlightenment stance towards women, pre-Enlightenment, and that this attitude countenanced and sanctioned the husband's right to rape his wife in a bedroom which was cordoned off from the criminal law. Criminal law immunised the husband from prosecution. Family law obliged the wife to perform conjugal duties. And the Anglican Church, through the Book of Common Prayer and the marriage service, commanded the wife to obey her husband. He referred to a government inquiry which had been conducted in the mid-1970s in South Australia, which captured this thinking among the legal community. So these are very influential lawyers writing and saying in this government report, it's only in exceptional circumstances that the criminal law should invade the bedroom to allow a prosecution for rape by a husband upon his wife with whom he is cohabiting might put a dangerous weapon into the hands of the vindictive wife. And he added, the Anglican Book of Common Prayer in 1963 used the word obey. Then in 78, it was replaced by what was called a New Australian Prayer Book, which offered a choice, and the choice was to have the word obey in it or not, and it set it out. He goes further, getting really stuck into the repulsive views of Australia in the 1960s. We had a white Australia policy. It was quite explicit. You really couldn't get into the country unless you were white, and there was in fact a language test. So I think if you were perhaps of Indian extraction even, you might be given a test in Irish Gaelic. And if you couldn't read in Gaelic, you couldn't get into the country. I'm not quite sure how long the language test, but it was such a clear method of excluding people from the country. Mr. Bennett said literally this, that Australia was a very unenlightened and socially backward country by modern standards and probably shared this status with most of the world. To Mr. Bennett, the criminal law, the church and the family conspired to keep married women in this pre-enlightened condition. The judges were highly offended by this. They kept on saying, look, we were actually a very progressive country, we Australians, much better than England. England was appalling. We had this and this and this. And they talked about their fellow judges, immediate predecessors, some who had expired. And they said they'd be turning in their grave to hear this. So you could see the way that the wind was blowing for Mr. Bennett. And Mr. Bennett said, I've acknowledged that there were green shoots, but that is all they were. In major matters, the women's movement had not achieved its major reforms. The majority of the High Court did not agree. It declared that the changes for women occurred well before, not only in 1991, when the common law of marital rape was condemned explicitly, but in 1963, and then they rolled it back to the beginning of the century. They said that 1935, when the rape law was legislated, but still largely defined by common law, that South Australia and the common law did not recognise this immunity. It was patent nonsense. Absolute patent nonsense, because everybody believed immunity existed and it was never prosecuted, the crime. But nevertheless, perhaps backed into a corner or made to feel bold, the Australian High Court in May, the 30th of May, said that the immunity did not exist in Australia at the beginning of the century and we had never received this English law. I should say Canada can never do this because Canada legislated the immunity. So this was a common law opportunity. The court declared that this was a common law offence and the highest court in the land could decide what the law was. The law was tested, found wanting and changed. I should say that my former honours student was the main counsel in this case and he'd done an honours thesis in rape. On rape law. So you may end up in the Supreme Court if you study, because he has really overturned the common law of rape. Quite extraordinary. It won't make a practical difference. The High Court knew perfectly well that the women of Australia who had been abused by their husbands for decades and decades were not going to come rushing forward. That's not going to happen. It's implicitly understood that this is really a much more symbolic and expressive change to the law. The dissenting judges thought that this was ridiculous. Of course, the immunity was in place. One judge said, it cannot be sensibly suggested that the appellant would have been prosecuted for those offences in 1963. It could not be committed by a husband against a wife, this crime. She said that the immunity was part of the received common law of Australia, as it was part of the received common law of this country. And she calls in aid Lord Hale, who is cited for the provenance of the rule, over and over again, century after century. Lord Hale died in 1666. He published posthumously 60 years later in 1736. That's where the rule was stated. It's been quoted ever since. That is the law. I can't believe it. Anyway, she quotes Lord Hale, and I will be talking about Hale in a second talk, but what she didn't mention about Hale was that he, who is regarded as one of the greatest lawyers in the common law world, also helped to convict and hang witches. He believed in witches, and it's this mentality which has endured into the late 20th century and really into the 21st century. Doing a little bit of cutting. Right. So, the different members of the High Court disagreed about the timing of the sexual revolution. The majority said that the revolution for women had occurred at the beginning of the 20th century, implausibly but authoritatively. That has become the law, the common law, because they can say whatever it is. The dissenting judges said, no, it happened later, but both agreed that criminal and civil law positively contrived to exclude married women from liberal legal personhood at some stage. So far I've been looking at this problem from the top down, and now I want to look at married women themselves and what they've had to say about their rights. And here I'm using this study by Simon Schrater and Kate Fisher. The book was published in 2010. It is probably the most authoritative study on married intimate life that's been done. It entailed interviews with 89 men and women, long open-ended interviews. They went into people's houses and eventually got them talking. And they were asked what sex had meant to them as adults and what part it played in their relationship. And eventually they came good and talked openly about their intimate life. And it wasn't a horrible, repressive, disgusting story by any means at all. It wasn't one of raw and brutal patriarchy. It was a mixed story. Social historians are always trying to get into the mentality of another time. And this study was very good at trying to understand the worldviews of men and women living and having sex in the 1930s, the 1940s, the 1950s, and before the sexual revolution. What they found was a strong link between love, intimacy, privacy, and sexual duty. So the story was complicated. The married women certainly did not talk of a right to exclude their husbands from sex. Absolutely, the opposite was true. They spoke of a duty, but it was a duty out of love and of social obligation. And they did not say it precluded sexual pleasure. This was a rich, well-rounded study of marital life. But many respondents presented sex as a duty. They accepted that the provision, and I'm quoting from the authors at the moment, many women accepted that the provision of sex was both a husband's right and a wifely responsibility from which they could not completely disengage. To the authors of this study, the conviction that a wife had an obligation to provide regular sexual access for her husband was relatively uncontested. That's what married women themselves thought about their bodily integrity and their rights to exclude. It was not seen necessarily as an unpleasant thing, though sometimes it was. It did entail consenting at moments when they did not want it for themselves. And for some, it was an unpleasant obligation. So this study supports the view that these married women did not regard themselves as liberal legal persons, and they did think that the obligation to be sexually available was part of the deal of marriage, what they signed up for as married women. The Schrader study, this study supports the dissenting view of the High Court, that the sexual revolution had not come, and the women themselves didn't think it had come. Life simply wasn't lived like that, and it wasn't necessarily a nightmare. And importantly, sex was something you didn't talk about. The strongest conclusion they came to was that it was a very private matter. Sexuality and intimacy and love were within the environs of the marriage, and privacy was essential for intimacy. Now, it's easy to see that this strong veil of privacy over marriage provided the preconditions for appalling abuse, because civil and criminal law were staying out of marriage, explicitly and implicitly. So it's a mixed story. Yes, these women and men were having ordinary lives. Many were happy, but if they did not want to sign up to sex, there was no choice about it, and they would keep quiet about it. That was the strongest theme. Now, going back to some of the major critics of marriage, Jeremy Bentham spoke of the family as a little kingdom, and John Stuart Mill, a blistering critique of this arrangement, was offered in the subjection of women. He said, above all, a female slave has an admitted right and an obligation to refuse her master the last familiarity, not so the wife. Not so the wife. However brutal a tyrant she may be unfortunately chained to, and I don't think any of these women in the study had brutal tyrants, because they wouldn't have participated in the survey, would they? So in some ways they were nicer people by definition. However brutal a tyrant she may be, unfortunately chained to, though it may be his daily pleasure to torture her, and though she may feel it impossible not to loathe him, he can claim from her and enforce the lowest degradation of a human being, that of being made the instrument of an animal function, contrary to her inclinations. And I don't think Germaine Greer could have said it better. These are not words that you... Have you heard of Germaine Greer? Fine woman who doesn't mince words. Strong, powerful language. He said that marriage positively created men of bad character, that the family, as respects its chief, is a school of willfulness, overbearingness, self-indulgence, and selfishness. That was Mill on marriage. Norbert Elias has also described in 1936 the privatisation and the withdrawal of marriage and intimate functions. Very interesting, but I haven't got time to talk about him. So all of this speaks of an alliance between law, the family, and the church to keep married women in their place and in a private place where they couldn't say anything, where they wouldn't say anything, where it was rude to say anything. And I can think of the women of my mother's generation who would shut up. This was not something to be talked about. It wasn't a communicative matter. It was a matter of seemly behaviour and propriety and keeping quiet, which didn't necessarily... This was not inconsistent with strength of character either. So the Christian church reinforced the rules for intimate life and for sexual contact between man and woman with the marriage service, the marriage sacrament, and was party to the exclusion of same-sex people from this union. It wasn't thinkable. Men and men were not going to get married in this way of thinking. In fact, the man and the man was grossly indecent. And hence the church and the law were hand in hand in really condemning gay relationships as grossly indecent and creating a criminal offence to match it. Feminists have often expressed concerns about the Catholic Church and its vocal interventions in women's reproductive lives, especially in relation to abortion. The Anglican Church has been more muted in its public commentary on the role of women and has attracted far less criticism, and yet it has been influential in setting some of the basic conditions of married life. And importantly, it has pressed for a private sexual order and the vows of marriage have been explicitly about obedience. The men and women in the Schrader study referred to their religious codes, and they thought the best way to observe them was to keep sexual issues to themselves. They thought that the private marriage was a proper religious marriage. So the church was party to this understanding of married life as a closed affair, and so a blind eye was turned to the brutal marriage, and women didn't talk about it when that was what was colouring their lives. The idea was that they would not rock the boat, and that comes very much out of this study. Rushing on to the sexual revolution, there have been great changes which I barely need to mention, and they've been reflected in criminal law. Recognition of gay marriage, changing form of the family, men and women live differently, recognition of gay partnership and gay abuse, the criminalisation of wife rape, which I think is now unthinkable that you wouldn't have criminal law at home in the bedroom. So criminal law has been changing the lives of women and responding to these changes. And yes, I think we are getting a different idea of a legal person. The liberal model of the person is being undone by these changes. The recognition of wife rape necessarily requires the husband to see himself in relation to a wife, who now bears certain rights against him. In Jennifer Nedelsky's terms, he acquires a new relational identity, I think, as he's now seen explicitly to be part of this relation. And the change to the provocation defence, which has changed here somewhat too, is also part of this. Is there a new legal person? I can make some tentative observations. I think women have been too critical to the idea of the legal person not to make a difference as their lives have modernised. Men as husbands have been over-individualised, not seen in relation to the wife, and the wives have been under-individualised. The recognition of wife rape in conjunction with a communicative model of sexuality and of sex calls upon the husband to now recognise this other person in relationship, and she acquires a greater individual identity. So he is coming into being as a man. I think men are emerging. The liberal individual is acquiring a sex. Men are emerging as men and women as women. Now, back to a bit of a lesson on the legal person. It's important to remember that the legal person is not a stable, solid, physical being. It's not a certain type of man or a certain type of woman. I'm slipping into this error. It's really hard not to. We do it all the time. But a legal person is not my physical entity standing here talking to you. Strictly speaking, it's not even a human being, as you know. It might be a ship, it might be a corporation. The legal person is a complex of abstract rights and duties, which can be legally recognised or withheld. Strong legal personality depends on a richness of rights and duties. It's an abstraction. More rights and duties, I think you can say, the fuller the legal person is. The High Court in PGA spent some time reflecting on the ways that criminal law gave and withheld rights to married women. The one act of violent sex, a physical thing, was both a legal assault and a rape if the woman was not married to the assailant, but only an assault if she was. And there were quite chilling moments when you could see the High Court imagining this. You know, you get to the point and that's illegal, but that's not illegal. And some of the judges said, well, it's preposterous. You can't even imagine it. But it's a set of legal rights. It's a set of legal duties, and that's what personality is. More rights you get, more duties you get, the more you are a legal person. And the more you are, I think, a political and a social person. So the wife's legal personality was waxing and waning in PGA. The more her rights were recognised, the more she was coming into being. But interestingly, and this is not said very often, so was the man's personality. We tend to think of the denial of the personhood of women as the prominent thing. As she's blocked from complaining of rape, her personhood is eroding. Her moral personhood, her political personhood, and her legal personhood. She just can't complain. If you can't get a foothold with a right or duty, you're just not there in law. That's the formal sense of it. But the husband is equally denied legal personality as a duty bearer if he cannot be charged with rape. His personhood, as someone who bears the important duty not to rape, all depends on law. So to repeat, his personhood is also at stake. If he does not bear a duty to respect the sovereignty of his partner, he is weakened as a liberal subject. He is a weak man. Hardly ever said. There's likely to be resistance to thinking of these new ways about the legal person, ways which truly factor in married women and men and recast the husband as a fully responsible moral and legal person. Criminal lawyers have tended to see the immunity as a sideshow in their writing. They are unaccustomed to seeing it as threatening the foundations of their thinking. It's just a blip on the side. And yet rape is critical to criminal law thinking. We seem to write about it and talk about it a lot. Murder and rape are treated as their mala in se, the two core wrongs, and it's here that criminal law is supposed to do its best work. Rape is treated as a true wrong to society, it's treated as the worst wrong, it's the worst way you could offend the dignity and bodily integrity of a person. And certainly lawyers in England and Australia would be saying that a polis that fails to criminalise rape properly is not functioning as a true liberal polis. It really goes to the heart of the good society, the good political society. Rape law should supply a case of best legal practice. But then the discipline of criminal law and lawyers has had to make sense of the spousal immunity, which is making sense of bad practice, bad recent practice. This has been achieved by often implicitly asserting the exceptional nature of the immunity, and as Change is discussed, talking about the correction of an anomaly, which is a way of really trivialising the significance of the immunity and significance of the change. Criminal lawyers have found willing moral allies, people of like mind among family lawyers and representatives of the church, who have been willing to keep this problem within one of the two core offences sublimated. It is not good for criminal lawyers, for their intellectual and moral health, for them to take this cheap and easy way out and say that marriage and wives were once a special case under a different set of social mores, and now we've come into the mainstream, problem solved. It is intellectually shoddy because it does not require any reflection on basic principles. It also fails to appreciate the significance of the spousal immunity for their basic understanding of criminal responsibility as it applies to men. Criminal responsibility is what criminal lawyers talk about all the time. What are the appropriate conditions of criminal responsibility? What mustn't you do and what mustn't you think? And this is about criminal responsibility as it applies to men. So criminal lawyers, given their deep interest in criminal responsibility, should be deeply interested in this, and especially since they have drawn a strong connection between responsibility and personhood. There is a very interesting literature among criminal lawyers on the connection between being held to account as a responsible person, someone who can respond to an accusation, and being a person. If you're not someone who can be spoken to, told you shouldn't have done that, what have you got to say for yourself, you are not able to respond, you are not responsible, you are not a person. You're not within the community of responsible persons. And outside the community of responsible persons, they have put children and lunatics and animals and, of course, married women sometimes. But the community of responsible persons is a very important idea within criminal law. So criminal lawyers should be terribly interested in how they have assigned responsibility. So I think they have a stronger interest than they think in the past exclusion of the husband from responsibility. The immunity not only unpersoned the wife, it unpersoned the husband. It removed him from the community of responsible persons into where? A lawless area and a moral vacuum, really. And so I've convinced myself that this marital immunity really goes to the very liberal foundations of our law, our common law in our countries. It's terribly significant. So I want to argue that there promise to be great changes to the legal person, understood in these various ways as a political idea, as a collection of rights and duties in this abstract way. But there's reluctance to think this way. It's still regarded as a bit of an oddball topic. Why are you talking about marital rape? It went away a while ago. It's not seen to have fundamentally important things to say about criminal law and the person. And in fact, I think things are beginning to go backwards, and I am frightened by what I'm seeing. This could be an important symbolic change. It could be revolutionary, actually, as a matter of principle at least, if not in practice. I've been studying rape too long to think that it's going to make a huge practical difference. But I think the way we think about law, it will do. It could force a rethink of the person. But change, this bringing married women into legal personhood is very fragile. Ominous signs of retreat. In the Schrader study, the married women were saying they felt they had a positive duty to be available. And Mr. Bennett reminded the court of the Anglican vows to obey. Last month, the Anglican Archbishop of Sydney proposed a return to the traditional marriage vows. In fact, he went further. Women would promise to submit to their husbands. This is now in the press. And I think it's about to happen, if it hasn't happened. So women are now going to be submitting if they want to submit. This is a very divisive thing. Things have changed. This creep, call him what he is very divisive in the church. This is a very offensive thing to say, but some people are going along with it. It wouldn't have been as offensive in 1963. It's very offensive now. Times have changed, mores have changed, the church has changed. This is not a liberal thing for an Anglican churchman to be saying. Within the writing of international criminal law, there's also a worrying trend. Harvard scholar Janet Hale is castigating feminists for their failure to appreciate women's ambivalence about sexual coercion and submission. Not a good idea. 50 Shades of Grey. Well, how many shades there are? Top 3 bestsellers is feeding this theme of female submission in popular culture. It is hardly a blink of time since all married women acquired the right to refuse sex. This fledgling right has just emerged in historical terms. It has not matured, and it should not be cut down in its infancy. Recent evidence from Ontario on the prosecution of wife rape has found that, and this is from Ruthie Laser, that the key justice players themselves presume sex and intimate relations. She interviewed prosecution and defence lawyers. And this is the best and recent evidence from your place. So the signs are not good. Typically, wife rape has been cast as a problem for women, but perhaps real change will only occur when it is cast as a problem for men and their personhood. The immunity was corrosive to male responsibility, to male character. And John Stuart Mill saw this so clearly. And these words are not being uttered in these strong, clear terms these days. It was corrosive to male character, corrosive to the political liberal ideal. It was corrosive to the person. It was corrosive to cater for what might appear to be a base male desire to govern women. Why would you want to go along with that? John Stuart Mill spoke of this underside of male private life and insisted that liberal law must govern the running of the home, not petty tyrants. So my final clarion call, the civility of men, their responsibility and their very character as persons, depends utterly on their civility to their wives, to whom they go home at night, should they be married. It also depends on their civility to their husbands, now that gay marriage is recognised. A civil law must demand this civility. Without this, Men are not persons. Finito.
Thanks so much for that. We have some time for questions now. So I'm just going to take a few questions. For the purposes of the taping, we need you to speak into the microphone with your question. So we'll take 2 or 3. Me too. We'll take 2 or 3 questions, and then we'll see where we are with the time. It's about 1:30.
Great talk, Ngaire, and I'm obviously very sympathetic to most things you say. My comment might be tangential, but I just want to rescue one aspect of the person from what you have said. You've talked of legal personhood, obviously, as a bundle of rights and obligations that is conferred upon a person by the law, something that is posited by the law. You also spoke of political and social personhood, presumably as a status that is conferred either by the polity or society in general.
Yes.
But you also mentioned this idea of moral personhood. And you spoke of it in a bit of a... You spoke of it in the same terms as you were speaking in terms of the others. You said, well, moralhood is something that can be diminished. It's something that can be eroded. It's possible that a legal regime could leave someone, a legal person, in a moral vacuum, right? And it seems to me that we don't want to lose this idea of moral person as being something different, something that is not posited by other humans, something that just is, right? It's a status that moral persons have. And why do they have the status? Because of the kind of entities that they are. They can understand the reasons that apply to them, the moral reasons that they have. They can choose to act on them. They are not controlled when they're not acting on them. And some people would say, well, the idea of having non-instrumental value is also added to this. This is some sort of benchmark, as it were, a ground on which to understand the value of someone. We don't want to make that relative to anything, because this is what we have to look at to criticize other accounts of personhood, such as legal personhood or political and social personhood. So I would just invite you and these might just have been slip of the tongue when you say this.
No, not slips, quite deliberate.
Okay, because I just want to say, one could say morality is morals, is social norms. That's not what I'm talking about. I'm talking about something that you and I want to agree. We say genocide is something that is bad. Sonia is a person, whatever people say. There is this idea, and on top of this are other ideas, such as legal, social, and political personhood. And I'm wondering whether that would be a friendly amendment or not, but it seems that it's not. So,
thank you very much, and I suppose everybody heard that. Your claim is really that there is some intrinsic, enduring, universal quality in human beings which transcends law and religion and is just there. It comes close to being a religious claim, I think, sometimes. I know atheists can also make it. I'm not sure about it. I think it's a wonderful ideal. I think it's jolly good having it there in human rights instruments. I actually think it can be extinguished. I think that moral personhood can...
People can be killed.
No, I think that Hitler may have lost it. And I think that the petty tyrant, perhaps they do lose their moral personhood. I probably am one who resists the idea of intrinsic, universal, human value, whatever. And I know that there's a major difference of opinion. And usually it's a difference across religion. It's not necessarily across religion. And I think it's a leap of faith. You either think people do have this, or you don't. And it's a tricky one. I'm a medical lawyer too. And on Monday nights, I go to a home for the intellectually disabled and sing with the profoundly intellectually disabled. One of the reasons I began doing this was so I'd like myself better as a lawyer, because lawyers are always likened to snakes and hideous people. And I thought, no, I'm going to be a do-gooder. I'm going to go and sing with the intellectually disabled. But I'm also interested in the work of Peter Singer, the great Australian ethicist who's done very provocative work on infanticide, and has argued that there is, one should not draw a species difference between humans and other animals, that it's not humanity per se which is intrinsic value, but the ability to feel, suffer, or have preferences. I'm quite sympathetic to that view. And one of the reasons I went to this home for the intellectually disabled was to see whether there were some human beings I would be willing to regard not really as persons at all, worth saving. And mainly I came away feeling that they were my friends, but not completely. So that was a test for me of my own values. There's one chap there, and I really wonder about his value as a human being. It's very, very harsh. And I'm there with the absolute worst cases. Mostly they're absolutely delightful. No, I wasn't going to turn them off, this life support machine. I went in there as setting myself a moral test. How would I feel about human beings who didn't have much left at all? And mostly I think, yes, there is something there that you're talking about. It's not always there. And I think with people whom I'm probably willing to call evil, I don't think they've got it either, which raises other questions about capital punishment, which I do not want to go into. I don't believe in capital punishment either, so it's morally difficult. Sorry.
Thank you so much for a terrific talk. I was hesitating about putting up my hand because I'm not sure I had a fully formed question, but I'm just wondering if I could invite you to reflect on how the marital rape immunity obviously lives on in practice in many ways, but the extent to which it has been dispersed beyond marriage over the course of the sexual revolution. We've obviously made progress in removing the immunity and removing the formal barrier to prosecution for rape in marriage. But at the same time, it seems that one of the things that's happened over the course of the last half century is the ideologies that accompanied the marital rape immunity have arguably now been reproduced in non-marital contexts, whether we're talking about non-married conjugal cohabitants, even if we're talking about boyfriend-girlfriend relationships. And I wonder if that's part of the kind of backward step over the course of the last few decades in your thinking, whether the work that still needs to be done, and I love the way you put it in terms of men's and women's personhood, that work needs to be done not just in marriage, but more broadly in other conjugal relationships or just about any sexual relationship.
Yes. So is the problem more broadly based? The problem is it's the whole of life, isn't it? I mean, it's what we go home to at night and how we think about it. I'm living in Church Wellesley at the moment in a gay block of flats. And I've never been so rare as a female. And there is a grouping of people who have clustered together out of sexual solidarity. I'm not quite sure what to make of that. In some ways, I think that if people are, ghetto is a horrible word, but if people are clustering together, there is still a felt need for protection. Privacy is still a problem. It's not integration. It's getting beyond the realm of my experience, which is very, very limited. I've been married forever. And I should say, very happily married. to a social historian who gives me good work to do. I think the problem is broad and wide. In some ways we've made progress. We do talk about it more. We talk about a communicative model of sexuality. Now, those women and men in the past didn't talk about it. I suspect talking about it is a very good thing. But then there's always something else happening. And I think the ongoing sexualization of women, and perhaps some men, is a real problem. It may have got more complicated. It's sometimes I think I'll retire early. It's a very difficult one.
Just a quick question about the makeup of the court with respect to the decision, the High Court, with respect to the decision you were discussing, in terms of the gender divide on the majority as opposed to the dissent. Just some insight on that. Were the women on one side and the men were on the other, or did it break down on non-gender lines in terms of where people stood?
Non-gender.
Okay.
2 women were in the majority, and 1 woman and 1 man were dissenting judges giving separate judgments. It was interesting. And so much was to do with how things unfolded in the court. I think if you offend judges enough, they're going to come back and say, we were enlightened. We never thought this way. How dare you? In fact, we always thought this way. In fact, I missed the hearing, which was in Adelaide, tragically, and a colleague of mine who had attended had a bet with me. She said, I know where it's going. They're going to say, of course, it could be prosecuted. And they went further. They said it wasn't even 1963, it was 1935, possibly before, and certainly we didn't even receive this law. So what judges do and say, I don't think that's a simple gender matter either. It's so much about how the parties put the cases to and their sensitivities and who they knew. And they're also fine legal thinkers.
I'm wondering if you have any thoughts on the unmarried woman after the sexual revolution and her sexual rights and freedoms. I'm thinking specifically as what I've seen as perhaps a bit of a backslide into, we're talking so much again about how she's dressed and how she put herself forward and whether she was involved in the hookup culture and all of this business. And it seems like perhaps as unmarried women, we are inviting a loss of protection because we've engaged in the post-sexual revolution behavior.
Mm. Yes, I agree. I really concerns me about the sexualization of young women, and this is just going into my general feelings as a person who reads newspapers and magazines. But the post-sexual revolution seems to be partly about women pleasing men again and doing it very explicitly. I think it's appalling. Yes, I think there needs to be a fresh feminist consciousness with all women and men calling themselves feminists. It's not a dirty word. And there's such a reluctance to use it. And I've waxed and waned at using it at work. I used to teach feminist legal theory, and then I thought it's too hard. And sometimes I teach big criminal law classes, and sometimes I come out fighting, and sometimes I haven't got the energy. But I think as lawyers, too, we have a moral responsibility to be talking about these things, because it does go to civil law, criminal law, family law. It runs right through the lot. You can't get away from it, can you?
Just as the mic is going to another question, Ngaire, I just wonder whether or not what you're describing, to the extent that there's a shift in the social sense of the person that's providing challenges to the law to restructure itself or respond. Your story kind of at the end around the Anglican Church and the wonderful reference at the end to what's happening right now with the marriage vows. Is there, do you think, a kind of extant sense of a changing person that's putting stresses on both law and religion in terms of how they respond to the sense of the person that they're dealing with? Or is this something where religion is sort of irredeemably kind of behind in this process, and that law and the political person are pushing ahead?
And which religion are you talking of?
Well, you were speaking about the church and...
Yes, well, I chose the most mild-mannered church. The others go further, except the Sydney Anglican Archbishop has said things which are offending people and are divisive within his own church. In some way, the churches are progressive. Different members within the churches are. One has to speak about which particular churches. And as I said, I've probably chose the politest, least interventionist church. Normally feminists talking about Christians talk about Orthodox Catholics. And probably the most well-known Orthodox Catholic, John Finnis, who was educated at my institution, just goes on and on and on about the evils of homosexuality, abortion, euthanasia, so on and so on. Now, and he's seen as a divisive but nevertheless very influential person. So who's coming forward and who's coming backwards? And from which parts of which churches? I know it's a very complicated story, with some religious people leading the way, I think, maybe.
Jen.
Hi, I'm wondering if you can say, so you were talking a little bit about you can change the law, but women, that doesn't necessarily mean that women who are experiencing sexual assault in kind of relationships or in partner, like in marriage, are going to come forward, but that for you it was still an important kind of thing. And there are a number of reasons that jump to mind, some more obvious than others, about why that is an important kind of fight to have. I'm wondering first if you can talk a bit about that, which ones are the most persuasive reasons for you, why kind of the battles that don't mean a lot necessarily for women's like day-to-day lives are important, and then more generally what your kind of narrative or sense of the role of law in a social movement like feminism might be, and kind of with that tension in mind, with like kind of people's practical lives and the higher up kind of theoretical.
Calling myself a criminal lawyer, I want criminal law to be getting it right, at least doctrinally, and in terms of adjectival law. I mean, laws which are this odious should not be on the books. I also, as a criminal lawyer, I'd like my other criminal lawyers to appreciate how their law has been tainted and how their main theories are often really very skewed by exceptionalizing certain things. So I would like to see criminal law theory changed. Then for practical change, yes, I would like it to keep pushing out. Certainly in Australia, rape is so rarely prosecuted successfully that I have a colleague who really did write a paper which was arguing that it should be made officially lawful, because then we'd be explicit. Let's just say it how it is. Now, what would that do as a political statement? Let's just decriminalise it fully and see whether it really makes much difference. It probably wouldn't. So I think as a lawyer, it's very important to me that the law gets it right, that criminal lawyers understand it well, that they factor it into their theories well. And yes, it would be wonderful if it were prosecutable. Many years ago, I was a police officer after my law school, and I had a very brief time in uniform and got to know some other police officers, and I know that they wouldn't go to court themselves. Criminal experienced women police officers wouldn't recommend it, and this was a long time ago. And I still feel this way. I mean, I can still so understand why one wouldn't want to foist this experience on anyone you know. And I don't know whether the best law possible is going to make it acceptable either. It's just such a difficult problem. It's really difficult, sadly.
Well, I think I can see that we all have a lot to think about now, so we're going to draw this to a close. And thank you very much, Ngaire, for giving us more to think about and for leaving us with these very difficult problems. I just we of course have to thank Ngaire for her talk and for her visit here. I just want to quickly draw your attention to the sign-up sheets in the middle of the tables for the LRST colloquium, and just quickly tell you that the next IFLS talk is on October 25th with Joanna Erdman, who's the new McBain Chair in Health Law at Dalhousie, Schuler. And the next LRST talk will be in late November with Richard Boone from Windsor, so you can look for announcements and tweets and all that stuff and watch our blog. But first, let's thank Ngaire. We have our traditional Osgoode gift.
Oh, good.
Full of homegrown tea. No,
Thank you very much.
So Ngaire is upstairs beside the research office on the 3rd floor. If people are interested in coming and talking to her more, she's here for about 2 more weeks. And it's just been an amazing part of our community. Just very, very quickly, after you clap, don't rush off. Some of you are here for the Women's Caucus meeting, so please stick around in the room, and the rest of us will just take food and leave quickly so the Women's Caucus can have their meeting. So, and I'm sure they'll be well primed to have their meeting. Thanks, sorry.